Hello again, it's Edmund Clements, and in this video, number 5, we're going to talk about the basics of ERISA. ERISA is the Employee Retirement Income Security Act of 1974. Let's give you a little bit of quick history. Back in the 1960s and 70s, there were a number of auto plants and other high-profile businesses that had fallen on hard times. One notable one was the Packard automotive plant, originally built in Detroit, Michigan. It had moved to Canada and was still struggling along for a few years, but then ended up declaring bankruptcy and leaving a lot of their pensioners without any of the money that was promised them. So Congress did get involved and created the Retirement Income Security Act of 1974. Quick fun fact, President Ford was actually eligible to play in the NFL, but decided to forego his football career after playing at Michigan and decided to go into politics, eventually becoming the president and eventually signing ERISA as probably one of the biggest pieces, if not the single biggest piece of legislation during the Ford administration. Now, the intent of ERISA was not to force employers into offering retirement plans for all of their workforce. It was simply to make sure that if a retirement plan was promised, that the employer had to live by certain rules and procedures and would be under the careful supervision of the federal government. Because federal law preempts state law, one of the intents of ERISA was to take any kind of a patchwork quilt of state regulation with regards to retirement plans and substitute it with one standardized set of rules and procedures. Now, those rules and procedures are pretty complex. We'll be talking to an attorney in just a few minutes. It is important to keep in mind that the federal government uses both the IRS and the Department of Labor through its subdepartment, the Employee Benefit Security Administration, to oversee employers' retirement plans. Let's take a look at one of the documents that the federal government produces to help employers understand their commitments under ERISA. This document is the Reporting and Disclosure Guide for Employee Benefit Plans. It's important to keep in mind that in terms of the federal government's oversight with ERISA, it applies to both so-called health and welfare plans as well as to retirement plans. And the rules for reporting and disclosure are quite complex, and because of the range of different programs that are out there, only some of the information contained in this 23-page guide applies to an employer who would be sponsoring a retirement plan. There's a copy of this document that will be in the operations manual that you'll get with Easy Savings for You. But taking a quick look, there's an introduction. There's an overview of some of the basic requirements of any program under ERISA, the summary plan description, the summary of material modifications, summary annual report, the notification of benefit determination, and plan documents. The next section has to do with health and welfare benefit programs. Scrolling past that, there is a section on additional requirements for retirement plans. And then even farther down, there's a section on an overview of the reporting requirements for retirement plans. And there's an overview of the commitments employers make to file their 5500s and keep the federal government up to date. As you can see, there's no shortage of government reporting and commitments to employees when it comes to these types of programs. In order to go into this a little bit more in detail, I'd like to introduce to you the attorney that we've got working on our program, Easy Savings for You. Hi, Doug. Thanks for joining us on this video. I know this is going to be a little bit different than some of our other videos. I thought these two topics, the basics of ERISA and the basics of qualified retirement plans, would probably be best served for our audience by just having a conversation with you. Can you give me a little bit of your background? What in particular, as an attorney, has given you kind of a deeper insight into how retirement plans work?
Sure. My first job as an attorney was with a law firm where the partners had both worked for Western Growers Association. I worked on both labor and employee benefit issues even at the beginning there, mostly though wage and hour, but not much in the way of ERISA. After a few years, I left to join Western Growers as a corporate counsel. And this is where I really began to focus on employee benefit and retirement issues. I provided counsel to the Western Growers Pension Plan and the Western Growers Assurance Trust, both of which operate under ERISA. And during that time, I moved up to Assistant General Counsel. And even then, I continued to spend most of my time dealing with ERISA issues related to the retirement plans provided by Western Growers. After 3 years as Vice President General Counsel with Western Growers, I began my new law firm. My 13 years diving deep into ERISA at WGA gave me really a great foundation for retirement planning. And since then, my 20 plus years in private law practice have been divided between both agriculture and commercial issues involving a wide range of employment issues, including ERISA retirement plan concerns.
That's a great background, Doug. I've heard of your involvement with the Western Growers Organization, and it does seem like you're the perfect man for the job in terms of our use of somebody who can help ag employers in today's climate deal with this Cal Savers issue. Can you tell me how much of your current time is spent on ERISA issues?
Well, that's hard to quantify. If I was to add it up, retirement planning is about 20% of my practice. As you know, I work with Mary Jane Eatson from the Eatson Compliance Center, and our normal days are spent providing guidance on everything from HIPAA privacy rules to questions about the health insurance marketplace. We provide legal opinions regarding ERISA compliance on everything from DOL and IRS penalties for, as you know, 5,500 returns to claims of discriminatory retirement benefits under ERISA. And obviously that relates to the retirement plans that we do work on. When addressing ERISA retirement plan administrations, it is important to realize just how complicated the ERISA statute is.
Well, that leads right into my next question. I have found in my career, I'm not an attorney, but as an employee benefit broker, working with self-funded plans, et cetera, there has to be at least a basic working knowledge of ERISA to survive and prosper. But I found that the issues of ERISA in helping employers in particular understand the nuances and sometimes just the vagueness of the way that the Department of Labor and the IRS deal with ERISA is a real challenge. Would you agree?
Right.
You find it hard to?
Absolutely. ERISA, it provides a very broad path for what employers have to do. And this includes health plans and retirement plans. And that determination, as far as ERISA is concerned, can have bearing on both federal and state law. So I agree absolutely that ERISA is a very difficult thing to have to provide by. And I think you mentioned in your question as ERISA is one aspect of the overall body of laws and regulations that business owners have to contend with. And that is true because it encompasses so many areas. ERISA is a very complicated area of law. Explaining the essence of ERISA, though, is easy. It is a regulatory law that covers health plans and pension and retirement benefits provided by employers. But once one drills down to the specifics of reporting and disclosure, fiduciary responsibilities, employee protections, vesting and preemption, it is a very deep hole for employers. There can be a lot of trips and a lot of issues that happen because of ERISA. I mean, for instance, ERISA preemption could be an entire class in law school. Trying to find an attorney who is really knowledgeable about ERISA preemption issues is a particular problem.
Can you give me a little insight as to how you would describe to an employer something that seems to the layman to be almost identical? They talk about reporting and disclosure. What's the difference? What are they talking about? And how are those concepts different in the legal sense of how the IRS and DOL look at it?
Yeah. Well, if you want a simple answer, reporting is to the government and disclosure is to the employees. The reporting part of ERISA is easy to understand and complicated to implement. There are plenty of guides published by independent authorities and even the US government concerning what reporting is required and how it must be implemented. The ERISA forms and reports provided to the government certainly do create a burden upon employers regarding the depth and the scope of what is required. That reporting is complicated and it takes a lot of time to get all the forms put together. As to disclosure, there are many similar guides on what must be disclosed to employees as there are for ERISA reporting requirements. Failure to satisfy disclosure requirements are just as severe as failing to file timely reports. When an employer starts to handle welfare benefits for any appreciable length of time, the employer becomes a fiduciary and owes an elevated duty to employees. This means that the officers or executives of the company are personally liable for failure to protect these employee funds.
I think that's always an important point, being able to explain to an employer, you are personally liable. You don't have a corporate veil over your responsibilities here.
Yeah, and that creates a real problem in terms of understanding what these reporting and disclosure requirements can lead to. Many executives aren't that familiar with what disclosure requirements are. I mean, disclosure requirements can be as simple as making sure the employer has the correct plan documents, whether it be health or retirement plans. It can be as complicated as making sure the employer takes steps to ensure consistent with ERISA sections 404A, 1A, and B, that these participants and beneficiaries on a regular and periodic basis are made aware of their rights and responsibilities with respect to the investment of assets held in or contributed to their accounts, and are provided sufficient information regarding the plan, including fees and expenses, and regarding designated investment alternatives. I mean, this can go on and on in terms of what the specifics are required under ERISA. And it certainly can trip up the staff employees that work on this, and then begin to include the executives, because they are the fiduciary responsible parties in this. In order for the employee to make an informed decision on these issues, it's important that they provided all these disclosure documents, what the management is of their individual accounts. So as you can tell, disclosure requirements are plenty complicated. And the DOL and the IRS can get pretty irritated if these disclosures aren't followed. So,
Can you give me a little more context in terms of the DOL and the IRS, the fact that those two powerful parts of our federal government both oversee this area of retirement planning? Do you find that one is more aggressive than the other in terms of getting in the employer's face, so to speak, or responding to employee complaints about a program? And layer into your answer there, if you would, what happens when there's a change in our presidency and the administration that's running ultimately this part of our government? Have you seen things change over the decades that you've practiced?
well, either the DOL or the IRS can be equally persuasive regarding enforcement. But it has been our experience that the IRS has, how would we say, more coercive tools for ensuring compliance. The IRS has the full power of its taxing authority and has more field agents that are available for enforcement. So it's sort of interesting, just in terms of the way these two independent agencies run into each other at times. And speaking of that, of course, we often run into situations where each agency is defending their own territory. The DOL and the IRS often have competing regulations that need to be addressed. And attempting to get clarity on a DOL regulation from the IRS has its own challenges. For instance, there are times when we've been working with the IRS and trying to get a DOL regulation interpreted, and they haven't been very helpful at all. So it can be a confusing situation when you have two agencies to have to work with. As to whether a Republican or Democratic administration has greater aggressiveness, I wouldn't say it's one or the other. I've practiced under administrations from Ronald Reagan to Donald Trump. And what it boils down to is that the bureaucrats and the bureaucracy don't change that much from one administration to the other. Sure, the agency head may change, but the underlying law is managed by the bureaucrats.
So you're saying there's kind of almost a deep state in the retirement plan world too.
Well, yeah, and it's funny. These bureaucrats keep on, year after year, and some may refer to this as the, deep state. But I prefer to think of it more as entrenched bureaucracy in a modern democracy, for better or worse.
You mentioned a term earlier, and I want to make sure we've got enough on it. Let's talk a little bit more about that concept of preemption. Can you explain it to a layman?
No. No, I can try. Preemption under ERISA is complicated, and how preemption affects the CalSavers plan, and really sort of a background into how California was able to get away with requiring a pension plan. So when Congress enacted the Employee Retirement Income Security Act, they provided that various states could not pass laws that might impact the new ERISA legislation. In legal terms, this federal superiority is called preemption. If a state attempts to require, for instance, that companies with retirement plans get a special tax break, maybe if you have a retirement plan, you get a special California tax break. A court would most likely say that if that's a qualified retirement plan, those tax benefits are preempted by ERISA and they won't be allowed. Effectively, preemption eliminates any state action that might impact retirement plans subject to ERISA, good or bad. Now,
I was just going to say, so how did California pull this off?
Right. So I was going to say, a good question might be, what about the new CalSavers plan? Does it affect retirement plans? How did they get away with that? Well, first, yes, it is in fact a retirement plan. But the key thing is whether the CalSavers plan is subject to ERISA. Is CalSavers, as noted in the ERISA statute, established and maintained by an employer? That's the key quote.
Yep.
Established and maintained by employer. And in the lawsuit brought by Howard Jarvis Association against CalSavers, the question of preemption is really at the heart of the dispute there. The claim is that CalSavers is preempted by ERISA. And in the final analysis, the ultimate question, as the Jarvis Association insisted, is whether or not CalSavers meets what is called the safe harbor rule under IRS regulations. As folks might know by now, payroll deduction IRAs are not subject to ERISA, so long as the payroll deduction is completely voluntary.
Right.
That is effectively what Jarvis maintains CalSavers is, a payroll deduction IRA. What the Jarvis Association claims is that because employers automatically enroll their employees into CalSavers, the program is not completely voluntary and not subject to the safe harbor exemption.
Mhm.
But interestingly, the decision by the U.S. District Court held that the safe harbor argument by Jarvis was irrelevant. The court merely applied a traditional ERISA preemption approach to its decision. What the court decided is that CalSavers does not in any way affect an ERISA plan's administration or any ERISA plan in general. Effectively, the court found that the state of California is not an employer and simply not covered by ERISA as a result. As the ERISA statute states, to be covered by ERISA, a plan must be established and maintained by an employer. The CalSavers program isn't established or maintained by an employer. California both established and maintains CalSavers, not the employer.
Okay.
Now, interestingly, the Justice Department has interceded in that case, and they're now involved. And the Justice Department maintains that requiring employers to deduct from employees' payroll means that employers are maintaining a retirement plan.
Right.
That's where their argument is. Further, the U.S. argues that the California law is preempted because it is connected with ERISA plans. I don't know about that part. It's sort of circular reasoning by saying that it's connected to ERISA plans because it's an ERISA plan. The CalSavers case, as you mentioned, will be decided by the U.S. Court of Appeals. And if that's yay or nay even, it's quite possible that it'll be appealed to the U.S. Supreme Court. In the meantime, unless a court somewhere along the way issues an injunction freezing the CalSavers program, employers must begin payroll deductions unless they're providing an alternative retirement program.
Yeah. So it's the law of the land here in California.
Yes.
Yes, it might change in the future, but based on court review, but good points. Thanks for helping us get a better handle on that element too.
Sure.
You know, I know we're talking about ERISA in this video, but I think as you and I have talked about off screen, there might be a little bit more attention paid by California regulators than the Department of Labor or the IRS to an employer, especially if they're going to pursue the easy savings for you direction using a payroll deduction IRA. Do you want to weigh in on that? What are your thoughts as to how California will be looking at these payroll deduction IRAs with automatic enrollment?
And specifically, the CalSavers program has a section in the Welfare and Institutions Code. That's section 12302.2. It's not relevant. The regulatory agency that would handle that is the California Secure Choice Savings Investment Board. And that oversees the implementation and enforcement of CalSavers. So that board reports to the California Treasurer, but they also have enforcement ability in and of themselves.
Okay. Well, I guess a lot is yet to be seen since they haven't engaged in any kind of enforcement yet, since the first deadline isn't up until September 30th. We'll probably not know anything until maybe well into 2021 as to what California is doing to enforce CalSavers requirements.
How do you stay up on top of this stuff? I mean, it's from my experience, especially now with the COVID situation, there's an awful lot of new updates coming out of Washington about what is allowed, what isn't allowed. How do you stay up on this?
Well, I read magazines. Mm-hmm. No, I'm just kidding. Actually, in the old days, I used online services such as Westlaw and Lexis. But in the age of instant news and information, I get much of my ERISA changes from, and really updates, from newsletters such as Ascensus or plansponsor.com. Today, a person can place an ongoing web search in Google and get breaking news on a variety of issues that way. Of course, when it comes to legal research, the old-fashioned ways still work. And I often get into that in terms of having to research decisions and cases that you actually need the actual case decisions on and the wording.